going to jail. Commit. Huh? You heard me? Oh, shucks, please. Make sure, hold on.
All right, good afternoon, ladies and gentlemen. It's 1:30. We're going to go ahead, even though we don't have inmates here yet, we're going to go ahead and do what work we can. I will tell you just some basic housekeeping rules. If y'all could please, if you're on Zoom, I need you to mute your microphone until your case is called. Also, if you're Zooming from home or your car, if you're doing something that you don't want all of us to see, and we are being broadcast on YouTube, stop your video. So I've just asked if you wouldn't do it in court, in person, please don't do it on Zoom. It's just distracting, sometimes humorous, but can be distracting. For everybody else, the inmates will have masks on at my request, and that's not for any other reason other than some of you may not feel comfortable dealing with someone that doesn't. If you want to wear a mask, wear a mask. If you don't want to wear a mask, that is your personal decision. It's up to you. And so with that being said, we'll go ahead and call the 1:30 docket for open announcements. Mr. Schmidt.
Gavion Singleton, he's appearing via Zoom.
It's him right here.
How you doing, Judge? No.
Good. What page is he on?
6, Your Honor.
All right, this is cause number CR 20-0456-173, the state of Texas versus Gavion Singleton. And this is set for status. Where are we at?
Judge, we've executed a jury waiver, and he just needs to be admonished on the record as to that.
Okay, do you have the jury waiver?
Should be turned in.
Yeah. Behind you, Brian. Do we have it?
Yes, that's okay.
Mr. Singleton, they're just looking for a document real quick. That's what we're waiting on. Is this the checkbook case? This isn't a checkbook case, is it?
Mm.
It's the PBCC check.
What we just talked about, yes, sir.
Well, you didn't give me any facts or circumstances.
I'm sorry?
You didn't tell me any real facts. Just talked about culpability and whatnot.
Yeah,
Okay,
it's one of those. Sorry.
that's okay. I assumed it was when I saw the charge. The court doesn't take documents. The clerk takes documents for the court. Because I have to sign it. But I mean, I like to sign it right there and go over it. Is it going to be a minute? Y'all want me to recall?
I can step back. It's up to you.
Yeah, because I mean, it sounds like it's going to be a minute.
Knock
So,
things out.
So- yeah, I'm going to handle Smith County. Mr. Singleton, they're still looking for that document. Don't go anywhere, but I'm going to go on to the next case. When they get it, we'll bring you back in.
Okay, yeah.
All right, and who do we have here from Smith County?
That's Mr. Stovall.
Okay, Mr. Stovall, can you hear me?
Yes, sir.
All right.
Page 3 and 4.
We're going to go ahead and call your case then. The case is, these are cause number CR 20-0070-0071, CR 21-0137 and 0138-173, and all are styled the state of Texas versus Stephen Stovall. And let's see, we have the two new cases set for arraignment, Mr. Head.
Your Honor, Mr. Stovall's name does appear correctly on the indictment. He understands the nature of the charge in each of those cases. We would waive the formal reading of the indictment and enter a plea of not guilty on each case.
All right, then, Mr. Stovall, the court notes your plea of not guilty in each of those new cases. And your two next court dates there are May the 12th and June the 9th, both at 1:30. And so let's move on to the two older cases. Now they're at status. We just want to hold those up.
Your Honor, if we could pass those to the May 12th docket
Sure.
and see where we are on the discovery at that time. I know Mr. Stovall has a pending charge in Smith County. We had tried to bench him over at one point, but we're not able to get him. So we're trying to work with the Smith County attorney over there to see what the timeline is on getting him wrapped up there so we can get him to Henderson County.
I could probably count on one hand the number of times Smith County is abided by my bench warrants, but
Yes, sir.
two hands, maybe more than that. Okay. All right. Well, then, Mr. Stovall, you understand all that?
Yes, sir.
All right. So what I'm going to do is I'm just going to hold these older cases up, set them for May the 12th when your newer ones are. And that'll give the state and your attorney some opportunity to go over discovery and talk some more. Okay.
Yes, sir.
All right. Thank you very much.
Thank you. Your Honor.
Mr. Stevens. What page? All right, this is cause number CR 20-0482-173, the state of Texas versus Jerry Cannon, and that is set for status. Where are we at?
Your Honor, we have received an offer from the state. We've rejected the state's offer. My client wishes that it goes on the trial document.
And what is the offer?
Oh, Judge, the offer was 5 years TDC.
Okay. All right, and state? Mr. Cannon?
Yes, sir.
Anything else to add to status?
No,
All right, then, Mr. Cannon, the court then deems status is held, notes that there's been an offer that has been rejected. Mr. Cannon, your case will be placed on a jury docket. I can't tell you when you can get a trial, but I can tell you this, it's starting to move and we're going to move real quick when we do.
Yes, sir.
And so can I see the docket sheet, please? So last time he was drug tested was back in December. All right, I'm going to order Mr. Cannon to take a drug test today based upon the nature of his charges and the length of time since his last drug test. Mr. Cannon, go to probation, take the test. When you get done, come back in the courtroom and we'll go over the results together.
Yes, sir. Thank you.
Yes, sir.
This is-
I need to talk.
We do?
Did we get a date on him? Did we get a date on Cannon?
Yeah, y'all didn't ask for another status.
You want to set up for board hour on the 16th?
Well, maybe his drug test will be either exculpatory or inculpatory as punishment.
He'll be
if we ever got
negative.
there.
He'll be negative.
Then maybe they would reevaluate their offer. He's been negative since December of last year, if that's the case. Next one,
Anthony Hewitt.
Anthony Hewitt. Alrighty, these are cause number CR 20-0083 and 0379-173, both styled state of Texas versus Anthony Hewitt and both set for status. Where are we
Yeah,
at?
Your Honor, we're going to ask you to drug test him right off the bat. Mr. Cox and I have been negotiating, and some of our outcomes going to have a result as his drug test. So before we go any further, we're going to drug test him.
Okay, well, Mr. Hewitt, then based upon the request from your own attorney, I'm going to order you to take a drug test. Go to probation, take the test. Have you done it before? You know the drill. When you get done, come on back in. We'll go over the results together.
Anthony. Hey, you are TT. That's bad. Feels like, man, don't take a drug test.
I left one of them good pens in my office.
Our two boxes of different-
I'm going to come back to Mr. Harris a little bit. Judge.
Okay. Thank you. Ooh, what is this? Is that a good one?
Sure, that's good.
Mr. Schmidt. Okay. Let me get back to where I was. All right, Mr. Singleton, we're gonna come back to you.
I'm here, Your Honor.
All righty. All right, back on the record and cause number CR 20-0456-173, State of Texas versus Gavion Singleton. Now, this case is set for status today. However, a waiver of trial by jury has been presented to the court.
Judge, that's not Mr. Singleton.
It's not, am I got the wrong one?
Nicole's phone.
Sorry, I just saw him right there.
Yes, sir.
All right, and so a waiver of jury has been provided to the court. It's been consented for by the state. And Mr. Singleton, I'm sure that Mr. Schmidt went over your constitutional rights to trial by jury. Is that correct?
Yes, Your Honor.
All right, I'm going to get you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God.
Yes, Your Honor.
You can lower your hand. Mr. Singleton, did Mr. Schmidt go over to you your constitutional rights to a jury trial?
Yes, Your Honor.
I'm going to cover just a little bit of it to make sure that you understand, because I have to make certain findings. You understand that the United States Constitution and the Constitution of the state of Texas guarantees you a right to trial by jury. Do you understand that?
Yes.
And you're the only one that can give that away. I can't take it. The state can't take it, and your attorney can't take it. It's your decision. Do you understand that?
Yes.
And you understand that it's my understanding that you have executed this waiver of jury because you have an agreement, you and your attorney, with the state. Is that correct?
Yes.
And you understand that if something goes wrong and from your end and you end up back in court, that if I sign and approve this and make certain findings, that you would no longer be entitled to a jury trial. You would only then be entitled, if you wanted a trial, to a trial before the court. Do you understand that?
Yes.
All right. And do you feel like you fully understand the implications of this waiver?
Yes, Your Honor.
Mr. Schmidt, do you believe that your client has entered into this waiver knowingly, intentionally, and voluntarily?
I do, Your Honor.
All right, when the court finds that he has, and the court is approving the waiver of jury. And Mr. Singleton, good luck to you. And I would just encourage you to abide by whatever agreement with the state that you have.
Thank you, Your Honor.
Yes, sir.
Thank you.
And you can go ahead and log off.
That's all I have on these shoes.
Yes, sir.
Thank you, Your Honor.
Thank you.
Mr. Head.
Your Honor, I had a client appearing by Zoom, Kennedy Milton.
Kennedy Milton. Is there Kennedy Milton? You know what the phone number is?
I do, Your Honor.
Got last 721. Is there a Kennedy Milton appearing via Zoom?
Three 3155 is the last four digits.
There's nobody on there like that. You want to give him a call or her a call?
Yes, sir. I will.
Okay.
And Anthony Poindexter is Justin's client.
Okay.
I was standing in for him this afternoon.
Zoom or live or
He's on Zoom, Your Honor.
okay, this is TP3.
It's
Ah, I see it right
Poindexter
here.
there. Yes, sir.
Mr. Poindexter, are you with us?
Yes, sir.
You have video?
Yes, sir.
He is on video. He's logged in twice.
Oh, I see him right there. So he is logged in twice. That's what I thought it was. All right, Mr. Poindexter, this is Mr. Head. He's going to stand in on your case. Do you mind?
Yes, sir.
You do mind or you don't mind?
Oh, no, no, sir. No, sir.
Okay. All right, this is cause number CR 20-0457-173, the state of Texas versus Tygan Poindexter, and set for status. Where are we at?
Your Honor, it's our understanding that Ms. Palmer had felt like there might be a conflict on this particular case. And so we think that Tonda Curry in Van Zandt County has been appointed, but we have not received any confirmation of that. If we could just reset it so we can find out for sure who the pro tem is on it.
And who appointed her? I don't remember, but if you said I did, I did. And I want to make sure, because it's changed since I've been the DA, if you can't just appoint anybody anymore, can you? It has to be another elected attorney. Is that correct? How about a county attorney? Okay, so, but does it have to be the elected or can it be their representative?
Our agreements on the other ones that we've done are the county attorney or.
Okay, they work under their commission anyway. Okay, fair enough. All right, then, so we're gonna have to reset this?
Yes, sir, Your Honor. I guess maybe Ms. Curry maybe didn't get notice or something. I'm not sure, but and I think they've been talking about a potential, or there'd been discussions prior to her being appointed with Mr. Hall about potential resolutions, but I don't think she's aware of all that.
Okay, well then let's do this. Then, Mr. Poindexter, they had to appoint somebody else to handle the state side of your case. So I'm going to reset your status to March the 15th at 1:30. Okay, sir?
Yes, sir.
You can appear just as you have today.
Yes, sir.
All right, so again, March 15th at 1:30 and you're free to log off.
Your Honor, March 15th.
Wait, 15?
What did I say, March? I have three.
March-
We have to pass March
Oh,
15th.
sorry.
Hold on, stay there.
April.
Oh, you made a mistake?
Yeah,
April 15th, 1:30,
Oh.
tax day.
All right.
I think coronavirus changed tax. But anyway, April 15th, 1:30.
All right.
All right, thank you, sir. You can log off. We'll get in a rhythm sooner or later.
Your Honor, if I can do a little work on a couple other files, then I'll report back.
Mr. Parrish. How are you?
Doing good. How are you?
Good.
Yeah, and I've got one case on the docket, Mr. Samuel Barron. He is in court, in custody.
Samuel Barron.
Want to just stand up?
Come on up. All right, this is cause number CR 19-0739-173, the state of Texas versus Samuel Barron, and this is set for status.
It is, Your Honor. I believe, well, just to kind of catch the court up a little bit, Mr. Barron has 3 pending charges in Gregg County that I represent him on, 3 felonies. I'm trying to get those cases resolved. I'm expecting a resolution in June, maybe early July. And I believe once I have his Gregg County cases resolved, we will then be able to dispose of the cases here.
The cases in Gregg County are of a higher degree than our cases here.
Yeah, but I don't like to wait on another county. I mean, they do them and we do us. But I understand that if it'll help move the case, then how far out do you want me to set it?
We're asking for August. I'm out most of July.
Well, let me ask you this, Mr. Barron. If we find a date in August, you're the one in jail. You all right with that?
Yes, sir.
Okay.
August 12th at 1:30.
That's fine.
August 12th, 1:30. And so we will reset status to August 12th at 1:30. And if y'all get it worked out sooner, get with Kevin and put it on the docket.
And we might, and just so the
Fair
court
enough.
knows, there's a co-defendant involved in Gregg County, so the state's trying to get that co-defendant's case done prior to
Understood.
his case. So that's what's going on there.
Good to see you.
All right, thank you, Judge.
Mr. Stevens. Juan Romo,
Page 8.
come on up. All right, this is CR 20-0510-173, the state of Texas versus Juan Romo, set for status.
Sure, we are set for status. There's a couple of videos that are supposed to be available for me on Monday that I need to show my client. There has been an offer of 15 years that's been extended. At this time, my client's rejected that offer. I don't know if the court wants to give us one more status, let him look at the videos and,
We're at status and you're just getting videos?
well, they were not provided to me and I had to check with the file and there are a couple of videos, so I don't know whether it's me that should have checked with them sooner or the DA should have gotten to me earlier. But that's kind of where the status of it is.
What was the
We
offer?
can put it on the trial docket if we trial announce it or one more status, whichever the court prefers.
Well, I mean, we're looking for a case for which day? The 16th. But we'll go ahead and I'll just go ahead and reset status. And if y'all want to try it on the 16th, maybe we can work something out. How long has he
I
been in
think
jail?
I'm already number one on another case for trial in your court.
In here? Okay, fair enough.
So I would not be ready for,
Understood.
I guess, back-to-back trials.
All right, then I'm going to reset status, let your attorney look at those videos. Mr. Romo, you okay with that?
Sure.
Okay, so I'm going to reset your case to April the 15th at 1:30. All right, we'll see you then, sir. Thank you.
Also have Melissa Allen for a plea.
Melissa Allen. Got something for me on that one? A warrant? It's starred, what's that?
That she still needs to be sworn.
Okay,
That we swore.
she has.
Sign it yet,
I think she did swear. I just haven't signed.
This
I
This
got
was a case that we were trying to give her here on several
it.
different.
Yep. Well, I saw the
benchmarks.
stars. That one, that tells me that they have a warrant, but I understand.
Yes,
why.
Smith County refused to honor.
He's the one who can hear it.
All right, this is cause number CR 20-0423-173, the state of Texas versus Melissa Lynette Allen. And set today for a plea is state ready.
We are, Your Honor.
And on behalf of Miss Allen,
We're ready.
ma'am, is your name Melissa Lynette Allen?
Yes, it is, Your Honor.
And are you the same person that was originally indicted by a Henderson County grand jury for the state jail felony offense of possession of a controlled substance?
Yes, Your Honor.
I can get you to raise your right hand as you can, please. You solemnly swear or affirm testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. You can lower your hand. Miss Allen, can you read and write the English language? Are you a U.S. citizen? If it turns out that you're not a U.S. citizen and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that? Miss Allen, have you ever been treated for any mental health or emotional issues?
Yes, Your
All
Honor.
right, and can you step up just a little bit? I'm having a hard time hearing you.
Yes, Your Honor.
And what would those be?
I have complex post-traumatic stress disorder and depression.
Okay, are you receiving any treatment for that?
Yes, I am.
And are you on medication for that?
Yes.
And are you receiving that treatment and taking the medication as prescribed?
Am I right?
Are you receiving treatment and or taking the medication as prescribed?
Yes, Your Honor.
I have to find that you're competent in order to
Yes,
take your plea.
yes, Your Honor.
I'm not being nosy. I have to ask these
Right.
questions. All right, and so you understand what's going on in here?
Yes, I do.
All right, and Mr. Stevens, do you believe your client is competent?
I do, Your Honor.
Well, Ms. Allen, even though you've told me you've had these diagnoses based upon your answers to my questions and your demeanor here in court, as well as your attorney's statement, the law presumes you competent. I find no reason to find you otherwise, so I'm going to find you are competent.
Thank you, Your Honor.
Ms. Allen, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom?
No,
Yeah, but do you understand the charge?
yes, sir.
Well, as indicted, that charge is a state jail felony. A state jail felony carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand the range of punishment?
Yes, Your Honor.
In the plea bargain?
Your Honor, it is 3 years deferred adjudication probation. She has 20 days credit towards any potential sentence. There's $1,000 fine, attorney's fees, court costs, lab restitution, and all the regular terms and conditions of probation.
Is that your understanding of the plea bargain, Ms. Allen?
Yes, Your Honor.
Is that your understanding, Mr. Stevens?
Yes, sir.
Well, Ms. Allen, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over the front and back of that document with Mr. Stevens?
Yes, Your Honor.
And did you sign it?
Yes, sir.
Do you have any questions about it? The next document I want to go over with you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that with Mr. Stevens?
Yes, Your Honor.
And did you sign it?
Yes.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents you went over with Mr. Stevens?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in this case?
No, sir.
Do you want to waive your right to a jury trial and enter into this plea bargain with the state?
Yes, Your Honor.
Then I'll ask you, ma'am, how do you plead to that state jail felony offense as alleged in the indictment? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, Your Honor.
I'll hear the evidence.
Your Honor, I had states 1 an offense report, states 2 is 3914 compliance, and stage 3 is a lab report.
No objection.
Admitted. Anything else from the state?
No, Your Honor, rest and close.
Rest closed as well.
All right, Ms. Allen, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court's going to follow the plea bargain, defer making any finding, places you on 3 years community supervision with 20 days credit as to any sentence you may eventually have to serve, and orders you to pay your fine, attorney's fees, court costs, lab fee, and to abide by all the regular and special terms and conditions of community supervision. Ms. Allen, have you ever been on probation before?
Yes, Your Honor.
Did you successfully complete it?
Yes, I did, Your
So
Honor.
you know what it takes, right?
Yes, Your Honor.
Do you know what can happen to you if you violate this probation?
Yes, Your Honor.
What can happen?
I can go back to work.
For how long?
At least 2 years,
Up to 2 years. Do you know how state jail time is served?
day by day.
Typically day for day. So here's what can happen. If you violate even one term or condition of this community supervision, a motion would be filed, a warrant would be issued for your arrest, you'd be placed in jail. You'd be brought before the court for a hearing. If the court found you had violated even one term or condition, the court could find you guilty, revoke your probation, and sentence you up to 2 years in state jail. You understand?
Yes, Your Honor. I
So would
do.
you agree with me? It's extremely important you abide by these terms and conditions.
I do, Your Honor.
I hope you do, ma'am. Good luck to you.
Thank you, Your Honor.
Thank you, Judge. That'll conclude my business. If I
Yes,
need
sir.
to.
Appreciate it. Mr. Mills.
Kelly Clark, please.
All right, Mr. Clark. All right, this is cause number CR 19-0531-392, the state of Texas versus Kelly Ray Clark, set for trial docket announcement today. However, a plea has been presented to the court. Is the state ready? And on behalf of Mr. Clark,
We're ready, Judge.
sir, is your name Kelly Ray Clark? And you have to move up, and speak a little louder. I know you got that mask and we have this glass.
Yes, sir.
And are you the same person that was originally indicted by Henderson County Grand Jury for this third-degree felony offense of possession of a controlled substance?
Yes, sir.
I get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Clark, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen, you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
Mr. Clark, have you ever been treated for any mental health or emotional issues?
No, sir.
You understand what's going on in here today?
Yes, sir.
And Mr. Mills, do you believe your client is competent?
He is.
Then a court finds he's competent. Mr. Clark, I know that we've already arraigned you on this case some time ago. However, would you like the prosecutor to read the indictment against you out loud in the courtroom?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years nor more than 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand the range of punishment?
Yes, sir.
And the plea bargain?
Your Honor, it's 2 years confinement in TDC with credit for 503 days served. He's responsible for attorney's fees, court costs, lab restitution. We're also asking the court to consider an unindicted PCS from January 14th, 2019.
Is that your understanding of the plea bargain, Mr. Clark?
Yes, sir.
Is that your understanding, Mr. Mills?
Yes, sir.
Well, Mr. Clark, a few minutes ago, you told me you could read and write the English language. I want to go over a couple documents with you. The first is the agreed plea recommendation. Did you go over both the front and the back of that document with Mr. Mills?
Yes, sir.
And did you sign the front and the back?
Yes, sir.
The next document I want to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both of those documents with Mr. Mills?
Yes, sir.
And did you sign the back page there?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you signed and went over with Mr. Mills?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in this case?
No, sir.
Do you want to enter into this plea bargain?
Yes, sir.
Then I'll ask you, sir, how do you plead to that third-degree felony offense as alleged in the indictment? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I'll hear the evidence.
Your Honor, it offers states 1 an offense report, states 2 is 3914 compliance, and states 3 is a lab report.
No objection.
Admitted. Anything else from the state?
No, Your Honor, rest and close.
And on
Rest.
behalf of Mr. Clark?
No, Your Honor, we'd rest and close.
All right, then, Mr. Clark, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third-degree felony offense. The court will follow the plea bargain, considers the unindicted PCS and sentences you to 2 years confinement in the Texas Department of Criminal Justice with credit for 503 days and orders you to pay your attorney's fees, court costs, and lab fee. And Mr. Clark, a couple more things before you go. Did you get an opportunity to review the judgment of conviction in your case?
Yes, sir.
Was your name, charge, and the time credit correct?
Yes, sir.
And finally, Mr. Clark, now that you have been found guilty of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about any of the circumstances about that or what that means, there's a document in your plea packet and/or you can consult with an attorney. Okay, sir?
Yes, sir.
All right, you're now remanded back to the custody of the sheriff for transport to the appropriate authorities to serve out your sentence. Good luck to you, Mr. Clark.
Yes, sir.
Please see the bailiff to your right. Anthony Hewitt. Mr. Cannon, pass your test, free to go, sir. Hold on, did I give him a reset? Oh, he's on the trial docket, that's right. Yeah, you'll get notice when your name comes up on the trial docket, which probably be sooner rather than later. All right. You too.
Alyssa Armstrong is here.
Alyssa Armstrong. Kevin, you're a month off on that. All right, this is cause number CR 20-0451-173, the state of Texas versus Alyssa Armstrong, set today for status. Where are we at?
Judge, I'm going to ask the court for another status. I think this is our first one. They've made a TDC offer. Ms. Armstrong came into the office last week and met with me, and we talked about that.
May I see the docket sheet?
We could just have a little bit more time, perhaps. She's obviously out on bond, and the offer was for a TDC sentence.
Well, let's go ahead and reset her then for April the 15th at 1:30. Is that all right with you, Ms. Armstrong?
Yes, sir.
All right, and so you're going to receive a reset notice there. Also, though, the last time you were in court, December of 10th of 2020, you tested positive for methamphetamines, amphetamines, and benzodiazepine. And so the court's going to order you to take a drug test. You'll go take the test just like last time. When you get done, come back in the courtroom. We'll go over the results together.
Yes, sir. What time on the 15th?
1:30.
I have Cassandra Jackson on the docket.
Okay. Cassandra Jackson.
Judge, I haven't seen her. She did email me last night and told me that she had COVID. I told her that she needed to either bring me a doctor's note or something or be here, and haven't heard from her today.
What was a plea time?
It was a plea for time served, basically, what we were
Okay.
supposed to do today. So I don't know. I don't know.
Well, if it's a plea for time served, I can't imagine she wouldn't show up.
Well, and she has been here before. She's
Right.
always zoomed in.
Right.
And so I don't know what to tell the court. She gave me the name of a medicine that she was on, which I didn't recognize.
Hydroxychloroquine.
No, it wasn't that, but it had a E.
I hear
on
that's
the
pretty
end of it.
good. That's what the president got.
Maybe if we could reset her to that April 15th.
Let's do that. I mean, if it's for time served, I hate to
Right.
issue a CAFES on her if she tells you she has COVID. All right, then I'll call it CR 20-0355-173, the state of Texas versus Cassandra Jackson. Was set for a plea today. However, it's been communicated by her attorney that she apparently has COVID. So the court's going to reset this to April the 15th at 1:30. And if you can make a note on the docket sheet, Madam Clerk, that her name was called 3 times and she was not here, in case she doesn't show up next time. And I didn't ask, so you have any objections to that?
That's fine, Judge.
Maybe we'll have better luck. Thank you, Judge. I think that's all I have.
I think that's it. Yes, sir. See you later. Mr. Stevens.
Daniel Higgins, you're on the floor.
Page number. All righty, this is cause numbers CR 20-0262-173 and 0263-173, set for a plea today on the 0262 case. Is state ready?
We are, Your Honor.
And on behalf of Mr. Harris,
Defense ready.
that's where you're going to step up a little bit. I'm going to have a hard time hearing you. All right. Sir, is your name Daniel Joe Harris?
Yes, sir.
And are you the same person that was originally indicted by Henderson County Grand Jury for the state jail felony offense of unauthorized use of a vehicle?
Yes, sir.
I'll get you to raise your right hand, sir. You solemnly swear or affirm that the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth to help you God.
Yes, sir.
And lower your hand. Mr. Harris, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen and you enter into this agreement with the state, you can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Harris, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here today?
No, sir.
And Mr. Stevens, do you believe your client is competent?
Yes, sir, he is.
And the court's going to find he is competent. Mr. Harris, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No, sir.
But you understand it.
Yes, sir.
Well, as indicted, that charge is a state jail felony. A state jail felony carries a punishment range of not less than 180 days, nor more than 2 years in a state jail felony facility, and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
However, it's my understanding that in exchange for your plea today, the state is willing to request this be reduced to a Class A misdemeanor theft of property, which would be a lesser included of the charge. The Class A misdemeanor carries a punishment range of not more than 1 year in the county jail and a fine not to exceed $4,000. You understand that range of punishment?
Yes, sir.
And the plea bargain?
Your Honor, it's 36 days confinement in Henderson County Jail with credit for 36 days served, $725 in attorney's fees, court costs, and we're asking the court to consider CR 2263, 173, and an unindicted DWLI from March 2nd of 2020.
And I ask, I guess a theft of property is a lesser included. Does it meet the Blockberger test or whatever it is as a lesser included of that charge? I mean, they're, okay, I'm just making sure. Because you could have done it another way under 1244, but I'm just making sure.
Or attempted.
Right. All right, and Mr. Harris, then is that your understanding of the plea bargain? All right, you guess.
Well, it's what we would over.
Let me ask you this way, 36 days on that theft charge?
Yeah, same thing we talked about.
Yes, sir.
All right, and Mr. Stevens, is that your understanding?
Yes, sir.
All right, well, Mr. Harris, a few minutes ago, you told me you could read and write the English language. I'm going to go over. That looks like I'm only going to go over one document with you because the other one's not in here, so I'll have to go over that with you orally. So, Mr. Harris, this agreed plea recommendation, did you read and go over both the front and the back with Mr. Stevens?
Yes, sir.
And did you sign it?
Yes, sir.
Do you have any questions about it?
Yes, sir.
Do you have any questions about any of the documents you read and went over with your attorney?
Yes, sir.
Well, if you read and went over these, there's normally another document that goes into detail, so I'm going to go into detail for you. First of all, you don't have to do this today, do you?
What's that?
Do this plea.
I don't guess I do.
No, you don't, right? You have a constitutional right to a jury trial. Do you understand that?
Yes, sir.
And at that jury trial, you could not be found guilty of this or any other offense unless the jury believed that you were guilty, all 12 of them beyond a reasonable doubt. Do you understand that?
Yes, sir.
And at that trial, you would have a right to, your attorney would have a right to cross-examine the state's witnesses against you. Do you understand that?
Yes, sir.
You'd also have a right to call your own witnesses or testify on your own behalf if you wanted to. You understand that? But if you didn't testify and you didn't call any witnesses, the jury would be told that they absolutely could not consider that at all against you. Do you understand that? There's normally a form that explains all this, but I don't have it.
That's fine. Yes, sir.
Okay, well, I have to explain it to you.
Yes, sir.
All right. And finally, if you were found guilty and you and your attorney made certain objections during the trial, and I was called upon to make legal rulings, you could appeal the jury's verdict and my rulings. Do you understand that?
Yes, sir.
But if you do this today, you're waiving all of that. Do you understand that?
Yes, sir.
Do you want a jury trial?
No, sir.
Do you want to waive your right to a jury trial, or do you want to enter into this plea bargain?
Yes, sir.
All right. Well, you answered yes to a compound question. Do you want a jury trial?
No, sir.
Do you want the plea bargain?
Yes, sir.
Then I'll ask you, sir, how do you plead to that lesser included Class A misdemeanor of theft of property? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Sir.
I'll hear the evidence.
Judge, I have states 1 an offense report and states 2 is Michael Morton compliance.
No objection.
Admitted.
Hey, rest of course.
Defense resting place.
All right, Mr. Harris, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that lesser included offense of that which is charged in the indictment, the Class A misdemeanor theft of property. The court will consider CR 20-0263-173 and the DWLI misdemeanor with previous conviction in sentencing you. Court sentences you to 36 days in the Henderson County Jail with 36 days credit in order to pay your attorney's fees and court costs. And before you go, Mr. Harris, have you had an opportunity to review the judgment of conviction in your case?
Yes, sir.
Is your name, the charge, and the time credit correct?
Yes, sir.
All right, sir. Good luck to you. And you need to see Mr. Halbert to your right. I didn't have that document in the plea packet, so I have to go over it. There's only certain things I have to go over, and that is one. Just doing it every now and then keeps me sharp. I'd rather just have the document. I could wing it.
You'd rather do it on the bird.
Put some on, put some words right in there.
He'd rather do it on the floor. Right.
That's
go talk to
only
him.
water. Oh, who do we got next? Mr. Head?
Yes, Your Honor. Jeffrey Rice on page 3.
All right, these are cause numbers CR 20-0331 and 0332-173. Both styled the state of Texas versus Jeffrey Rice, and both set for status.
Your Honor, I've conveyed the offer that was made to Mr. Rice. He does not wish to accept that and understands it'll be placed on a jury docket.
And I've got two questions. What is the offer and how long has he been in jail on these charges?
Your offer, the offer was 2 years on the assault, take into consideration the other charge.
Okay.
Mr. Rice has been in jail a little over a year now, I believe. Is that right?
Right at a year.
Right at a year.
Yes, sir.
Mr. Rice, you know, where is he at? He's pretty far up there, isn't he? No, you know, with nine above you. Normally, when somebody tells me they've been in jail a year, I wonder why we haven't given them a trial, but you know why we couldn't give you a trial.
Right, sir.
And so I know who to blame it on, but I probably better not, because I might get canceled. But it is called the Chinese coronavirus.
Yes, sir. I understand.
And so you know, I hope I can give you a trial soon. I think it's going to start moving fast, but I'll note that you rejected the 2-year offer. And your case will be placed on the trial docket.
All right. Thank you, sir.
Yes, sir.
Gunner, Damian Williams in custody.
Mr. Williams. All right, this is cause number CR 20-0253-173, state of Texas versus Damian Williams. And this is set today for pretrial. Where are we at? Any pretrial from the state.
Judge, just our motion for discovery.
No objection, Your Honor.
Granted. And first, Mr. Head, do you have all your discovery?
Your Honor, we have received quite a bit of discovery. I believe we have everything. I'm not aware of anything that's still outstanding at this point in time.
I can't think of anything that they don't have either, Your Honor.
Okay. And so then you're ready for pretrial?
Your Honor, we don't have any contested pretrial motions on file other than we did file a motion to reduce bail. We'd ask the court to just carry that over right now. There've been some discussions going on and about certain issues, and we just carry that on at this point rather than request a hearing today.
All right, well, then the court will deem pretrial is held. Mr. Williams, your next court date is status, and that'll be on April the 15th at 1:30. And has there been a plea offer extended?
Not at this time, Your Honor.
All right, and so when we get together for status, we'll kind of figure out where we're at. All right, sir. We'll see you back in April.
Your Honor, Kennedy Milton, he was the individual. I had given him a Zoom link for today. We've been texting. Apparently the Zoom link I sent him showed that it was expired from March 4th, but it's, I'm not sure. It's probably a technology error on my
Right, so I'm using
part.
the same one.
Did you text it to me? I don't do. I don't have it. Can you send it? Okay. The way you can text me. I don't get email on my phone.
You don't know how to set that up?
Yeah.
Or is that purposely you don't get emails on your phone?
It's on purpose.
Okay.
Yeah.
That should, maybe I should do that.
Okay. I apologize, but he's on standby. If I can just get him the right link, we'll get that taken care of.
Okay, and then we have Alvina Warren. Did we already do that one?
No, Your Honor, she called my office and spoke with my legal assistant at about 11. Said she was extremely sick, that she had been exposed to someone with COVID. We have an agreement for a deferred. If we could just roll that to the next docket, she's appeared on several occasions. Like I said, we have an agreement. And she did contact the office.
If it's for deferred, then I can't see any reason why she wouldn't show, so. All right, I'll call it CR 20-0392-173, the state of Texas versus Alvina Warren. Any objection from the state if I just pass this until April 15th?
No, Your Honor, that's
All right, well then, I guess I'll make a note. She's not in the courtroom. She's not on Zoom. If we can just check in the lobby, that way she doesn't show the next time.
Yes, sir. Cameron Elder, Your Honor. He is present.
Cameron Elder. Any answer? All right, and the court will note that her name was called 3 times in lobby and she did not answer. But again, I'll pass it. All right, this is cause number CR 20-0371-173, the state of Texas versus Cameron Elder. Set today for a plea. Is state ready?
Yes, Your Honor.
And on behalf of the defendant,
Your Honor, we do have the offer. However, there's a pending misdemeanor as well. We need to try to make sure we're getting that wrapped up as well. If we could just reset it one time to make sure we have everything in order and to allow me to go over everything with my client.
April 15th.
Yes, sir, Your Honor.
All right. April 15th at 1:30. Mr. Elder, remember any conditions of bond you're on. Once you receive your reset notice, you're free to go. I'll see you in April and stay in touch with Mr. Head.
Thank you.
Yes, sir.
Then, Your Honor, I have some plea papers I'm working on. If I could do that for a few
Circle back
minutes.
around.
Yes, sir.
Mr. Herring.
Yes, sir.
All right, this is cause number CR 20-0448-173, the state of Texas versus Tommy Hatton, set for status.
Your Honor, we have a plea to present to the court.
Oh, okay. I don't need the file, just you can put the file up here and hand me the plea papers. Mr. Hatton, if you could step over, Ms. Moore, can you give us just a little room? So he can swear to these? All right, this is cause number, I've already called it. Let's see, this case was set for status, but a plea has been presented to the court. Is the state ready?
We are, Your Honor.
And on behalf of Mr. Hatton,
Present ready, Your Honor.
sir, is your name Tommy Lee Hatton? Are you the same person that was originally indicted by Henderson County Grand Jury for the state jail felony offense, burglary of a building? I can get you to raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth to help you God. You can lower your hand. You got him abandoned in Chet State Jail. Is he pleading true on the first and second, and that's a second?
He's pleading true to the enhancement paragraphs, Judge, to make it a second degree fine.
It's checked as a state jail.
It's indicted as a state jail, but punishes at 2 to 20.
I got you. All right, and Mr. Hatton, you the same person that was charged with that burglary of the building?
Yes.
Okay, I think I already did that. Mr. Hatton, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes.
If it turns out you're not a U.S. citizen and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Say it again.
And Mr. Hatton, have you ever been treated for any mental health or emotional issues? You understand what's going on in here today?
Yes, sir.
And Mr. Harrington, do you believe your client is competent?
I do, Your Honor.
And the court finds he is competent. Mr. Hatton, I know we've already arraigned you on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom?
Yes, sir.
Do you understand the charge?
Yes, sir.
Well, as indicted, the original charge without enhancement paragraphs would be a state jail felony. A state jail felony carries a punishment range of not less than 180 days, no more than 2 years in a state jail felony facility, and a fine not to exceed $10,000. Do you understand the range of punishment?
Yes, sir.
However, it's my understanding that you are going to plead true in exchange for this plea bargain to 2 enhancement paragraphs.
Yes, sir.
If the court finds those truths and finds those true, then the punishment range would be that of a second-degree felony, which carries a punishment range of not less than 2 years or more than 20 years in the Texas Department of Criminal Justice. Do you understand? And a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
And the plea bargain?
Your Honor, it's 4 years confinement in TDC with credit for 302 days served plus attorney fees and court costs.
Is that your understanding of the plea bargain, Mr. Hatt?
Yes, sir.
Mr. Harrington, is that your understanding?
Yes, sir.
Mr. Hatton, you told me you could read and write the English language. I'm going to go over a couple documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back with Mr. Harrington?
Yes, sir.
Did you sign the front and the back?
Yes, sir.
Do you have any questions about it?
No.
The next document is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over that document with Mr. Harrington?
Yes, sir.
And did you sign it there on the second page? Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents
No, sir.
that you read and went over with Mr. Harrington? Well, if you read and went over these with Mr. Harrington, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in this case?
No, sir.
Do you want to waive your right to a jury trial and enter into this plea bargain with the state?
Yes, sir.
Then I'll ask you, sir, how do you plead to that burglary of a habitation as alleged in the indictment? Guilty or not guilty?
Pardon the building.
I'm sorry, did I say burglary of a habitation?
Yes, sir. I think
I'm sorry.
it's-
I'll withdraw that, and I'll withdraw that plea. Mr. Hatton, how do you plead to that burglary of a building as alleged in the indictment?
Yes.
And are you pleading guilty because you are guilty and for no other reason?
Yes.
And, well, I'll hear the evidence and then I'll take it from hand. Plead true.
Judge, I have stage 1, an offense report, and stage 2 is Michael Morton compliance.
No objection.
Admitted.
State rests and closes.
Rest and close.
All right. And then, Mr. Hatton, based upon the evidence in your guilty plea, the court has enough evidence to find you guilty and does find you guilty of that burglary of a building as alleged in the indictment. Now, Mr. Hatton, as to the enhancement paragraphs, is it true or not true that in 1996, in 173rd Judicial District Court, you were finally convicted of the felony offense of theft. Is it true? And is it also true that before that offense was final, in 2008, you were convicted of the felony offense of burglary of a habitation in the 173rd District Court? Is that true or not true?
True.
Are you pleading true because those are true and for no other reason? Then I'll find they are true. And Mr. Hatton, now that I found you guilty and found the enhancement paragraphs true, the court will follow the plea bargain, sentences you to 4 years in the Texas Department of Criminal Justice with credit for 302 days and orders you to pay your attorney's fees and court costs. And a couple more things before you go, Mr. Hatton. Have you had an opportunity to review the judgment of conviction in your case?
Yes, sir.
Is your name, the charge, and the time credit correct?
Yes.
And finally, Mr. Hatton, I know you've got those prior felony convictions, but I need to tell you anyway that you are now and have been under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, refer to the document in your plea packet or consult with an attorney. Okay, sir. All righty, sir. You need to see you. Good luck to you. You're now remanded back to the custody of the sheriff for transport to the appropriate authorities to serve out your sentence. You need to see the bailiff.
I'd be excused, Judge.
Yes, sir. Appreciate it. You know what would make it easier and flow better is if I had just admonished them on that firearm deal in the middle. I hate doing it at the end. So if it takes us forever to do that. And also being urgency, if you're being urgent to discuss firearm ammunition. Yeah, I understand. Did you go over that document? No. All right, anybody in the courtroom before I move on to Zoom? All right, Mr. Green.
Hannah Wolf, Judge, for an arraignment and a status conference.
Hannah Wolf.
Judge, I know she's there in the building because she's been blowing up my phone wondering where I am.
You're right here.
All right, exactly where I'm supposed to be, or can be, or however you want to say it.
It's a new world. Hannah Wolf, your attorney's been here the whole time. You just couldn't see him in one of those little boxes. You've been watching all of this go down. All right, this is cause numbers CR 19-0134-173 and cause number CR 20-0604-173, both style, the state of Texas versus Hannah Wolf. And Mr. Green, if we could arraign her on the 0604 case.
Judge, she's charged with by indictment with failure to appear. She understands she's been accused of that. Would waive the reading of the indictment. Her name is spelled correctly as well, and enter a plea of not guilty.
All right, Ms. Wolf, then the court notes your plea of not guilty for purposes of arraignment. And your next two court dates in that case are May the 12th at 1:30 for discovery status, and then again on June the 9th at 1:30 for pretrial.
So May the 12th and June 9th. Yes,
You're
sir.
going to get it in writing.
Yes, sir.
And then finally, on the robbery case, it's set for status. Mr. Green, I'm just going to roll it to May 12th with the others. Is that all right?
That's fine, Judge. I appreciate that. Mr. Cox and I have had some discussions preliminarily concerning that case. So we do have a dialogue going. And we'll see, where that gets us. We should have an answer by May 12th for sure.
Okay. All right, Ms. Wolf, once you receive your reset notices, then you're free to go.
Thank you so much.
What else you got, Mr. Green?
As far as I know, that's it, Judge.
I appreciate your patience. Thank you.
Thank you, Judge. May I be excused?
Yes, sir.
Thank you.
All right. Anybody else got anything ready? All right, I'm just going to go through the docket. If you hear your name called, I don't need you to come up. Just let me know that you are here. Jacob Mormon. Got you. Your attorney's, I think, working on paperwork. Jerry Moyer. In the jury room with Mr. Head. Okay. Rodney Greer. Okay, your attorney's here. You ready on that, Ms. Moore? Are y'all working on something?
I'm working on something with Mr. Cox.
Okay. So we'll just want to make sure you're here, Mr. Greer. Patrick Massey. Mr. Massey, I just wanted to make sure you were here. Are you talking with your attorney? He's here somewhere, so they're working on it. So, all right, anything else ready?
I almost have one lady. We're gonna sign a jury waiver on Mr. Hewitt and ask you to reset it.
Okay. You ready? Has he signed it yet?
No, Judge, I think we're good.
While y'all are doing that, Miss Armstrong, come on up. Yeah, I see the docket sheet. Miss Armstrong, who's your attorney? All right, this is cause number CR 20-0451-173. Back on the record in the state of Texas versus Alyssa Armstrong. Ms. Armstrong, I don't want you to say anything because your attorney is not here. However, the court has authority over bond and can find the bonds insufficient for any reason without a hearing. Ms. Armstrong was, say for any reason, for a good reason. Ms. Armstrong had tested positive for methamphetamine and other things back on December the 10th of 2020. Based upon the nature of her charges, she was drug tested again today. And today she has tested positive for methamphetamine and admitted apparently to smoking meth back on March 14th. And so what is her bond at now? I know I've raised, I should have raised it once. And maybe I didn't. That was the first one.
It's 50,500.
It is currently 50. All right, then, Ms. Armstrong, the court finds your bond insufficient. The court doubles your bond, and it's now $100,000 surety bond. And so I need you to have a seat in that jury box, and we will let Mr. Mills know what just happened. What are you giving me here? Oh, there's that. Both those. All right, let me call this Mr. Hewitt. Come on up. All right, these are our cause numbers, CR 20-0083 and 0379-173, both styled state of Texas versus Anthony Hewitt. And the waiver of jury trial has been presented to the court. And let's see, on both cases, or a document that covers both cases, Mr. Hewitt, I need you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Mr. Hewitt, I have been presented this waiver of jury. Do you recognize that document?
Yes, sir.
And did you sign it?
Yes, sir.
All right. And Mr. Hewitt, do you understand that nobody can make you enter into that? Do you understand
Yes,
that? I can't, your attorney can't, and the state can't.
Yes, sir.
You have a constitutional right under the US Constitution and the Texas Constitution to a trial by jury.
Yes, sir.
12 jurors.
Yes, sir.
And you couldn't be convicted unless all 12 found you guilty beyond a
Yes, sir.
reasonable doubt. However, by entering into this waiver of jury, if something goes wrong with whatever agreement you have with the state, you would no longer be entitled to a jury trial.
Yes, sir.
Because then you would only be entitled, if you wanted a trial, to a bench trial. In other words, a trial before the court where one person was making a decision.
Yes, sir.
You understand that? All right. And do you feel like you fully understand
Yes, sir.
what's going on? And see, Mr. Stevens, do you believe that your client has executed his document knowingly, intelligently, and with full knowledge and voluntarily?
Yes, sir.
All right, and court finds that the state has consented and that the defendant has entered into this knowingly, intelligently, and voluntarily with full knowledge of the consequences, and the court has signed it.
Judge, what we'd like to do is set it for a plea.
What day? I've already set it for, well, when did I set this, or have I?
Well, this was a status setting, so I'm not sure if there's another date.
When do you want it?
I don't, 2 or 3 weeks out at least. How much time do you need?
If
Maybe
I,
sometime in April.
how about April 15th? That's when it would have been reset anyway. Okay, April 15th, 1:30.
Just so
You
we're
gotta
all on
wait
the
for your
same,
reset notice.
just so we're all on the same page, that offer goes away on the 15th.
Well, what's the offer? Let's put it on the record.
18 months probated for 3 years.
18 months, probated 3 years, and it goes away on the 15th, should he not show. Is that correct?
Yes, sir.
Okay.
Judge, could we do a different date? I've got 6 cases set in the 86th District Court at 1:30 in Kaufman.
Casey Blair.
It is.
Shelton taking the bench yet?
Yes, yeah.
April 13th, 1:30.
That'll work.
And is the offer now conditioned on the April 13th at 1:30 date?
Yes, sir.
All right, so for the record, the offer expires from this, according to the state, April 13th, 1:30, should he fail to show. See you on the 13th, sir.
That's it for me, Judge. Might be excused.
Yes, sir. See you. Anything else? Going once, going twice. Ms. Moore? Okay, we'll go ahead and take our mid-afternoon recess. Y'all let me know when you got something ready. All right, everybody decides where and when. Got a lot of single file.
Sending myself an email. What is my train of thought? Yes. Okay.
Yeah. And then they took out your name, just passed it around to other people. I have some copies that were sent in. You did not.
And I wouldn't pay attention to you.
Shows 36 days, you showed about 36 days.
Take the order for fucking
I don't have an order for release.
You don't need. You don't need.
Oh, yeah. I didn't pay attention. Here, hold on, stand by. Here.
You'll have to pay attention.
So Daniel Harris. I thought I don't send to the jail, I sent to Sherry. Yeah, I already did.
Those two. Okay. Sorry about that. No, every time I think of it, it's one.
Everything that's left is the Ken Strong show, right? But you can tell her to stop. I think your nail.
Ruth. Did Jeff give you that visual?
Yes, I.
You may have it, so we can get that.
For you to tell me no, but do it before I do the paperwork.
It's on the box right beside one of that one. But it's on the box. I got it.
All right, continuing on 1:30 docket announcements. I understand we have something ready.
Your Honor, Kennedy Milton should be on the Zoom link now. There he is.
Okay. With this plea,
Your Honor, we have a discussion for a pretrial intervention. He is in Iowa playing basketball. If we could reset it to mid-May when the semester's over, he's from the Metroplex. He'll be back in Texas and we could do it in person at that time if possible.
okay. Got a date? All right, this is cause number CR 20-0455-173, the state of Texas versus Kennedy Milton was set for a plea today. Mr. Milton's in Iowa. The courts allowed him to appear via Zoom. And by agreement, the court's going to reset this to May the 13th at 1:30 for resolution. Got that, Mr. Milton?
Yes, sir.
All right, we'll see you back in May.
Yes, sir.
Now stay in touch with Mr. Head and you're free to log off.
Take care.
Yes, sir. Yes, sir. You too.
Anything else?
Your Honor, we're ready on Mr. Moyer and Mr. Mormon, whichever one the court wants to do first.
Let me see. Let's see who's first. Who is it, Mr. Moyer and who?
Mr. Mormon.
Let's do Mr. Mormon first. He's first on the docket. All righty, this is cause number CR 19-0263-392. The state of Texas versus Jacob Brant Mormon. And this is set today for a plea. Is the state ready? On behalf of Mr. Mormon.
He is present. We're ready, Your Honor.
All right, sir, is your name Jacob Brant Mormon? And are you the same person that was originally indicted by a Henderson County grand jury for the third-degree felony offense of unlawful possession of a firearm by a felon?
Yes, sir.
If I can get you to raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Mormon, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not a U.S. citizen and you enter into this plea bargain with the state, you could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Mormon, have you ever been treated for any mental health or emotional issues?
No, sir.
Is that a no?
No, sir.
All right. And do you understand what's going on in here today?
Yes, sir.
Mr. Head, do you believe your client is competent?
He is, Your Honor.
The court's going to find that he is competent. Mr. Mormon, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as originally indicted, that charge is a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
However, it's my understanding that you have an agreement with the state whereby in exchange for your guilty plea, they would recommend that the court basically convict you under the lesser included of attempted possession of a firearm by a felon, which is a state jail felony. A state jail felony carries a punishment range of not less than 180 days, no more than 2 years in a state jail felony facility, and a fine not to exceed $10,000. Do you understand those ranges of punishment?
Yes, sir.
And the plea bargain in the case?
Thank you, Judge. The state is prepared to go forward on the lesser of the attempted. The agreement is for 20 months state jail time, a credit for 595 days.
Is that your understanding of the plea bargain, Mr. Mormon?
Yes, sir.
And is that your understanding, Mr. Head?
It is, Your Honor.
Mr. Mormon, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first of which is the agreed plea recommendation. Would you read and go over both front and back of Mr. Head of this document?
Yes, sir.
And did you sign the front and the back?
Yes, sir.
Do you have any questions about it?
Yes, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that with Mr. Head?
Yes, sir.
Is that your signature there on the bottom?
Yes, sir.
Do you have any questions about it?
Yes, sir.
Do you have any questions about any of the documents that you went over with Mr. Head related to this plea?
No, sir.
Well, if you read and went over these with Mr. Head, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in this case?
No, sir.
Do you want to enter into this plea bargain?
Yes, sir.
Then I'll ask you, sir, how do you plead to that lesser included offense of that which is charged in the indictment? How do you plead to the state jail felony attempted possession of firearm by a felon? Guilty or not guilty?
Guilty.
I said, how do you plead twice? I don't know why. So you plead guilty to the attempted possession of firearm by a felon.
Yes, sir.
All right. And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I'll hear the evidence.
Thank you, Judge. State offers and the states one, the offense report, and states two are working discovery.
No objection, Your Honor.
Admitted. Anything else from the state?
Nothing further, resting close.
Mr. Head?
Your Honor, we'd rest and close.
All right, then, Mr. Mormon, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that lesser included of the charged offense, the state jail felony, attempted possession of firearm by a felon. The court will follow the plea bargain, sentences you to 20 months in a state jail felony facility. You have credit for 595 days and orders you to pay your court cost. And a couple more things before you go, Mr. Mormon. Did you get an opportunity to review the judgment in your case?
Yes, sir.
Is your name, the charge, and the time credit correct?
Yes, sir.
All right, sir, now that you've been convicted of this felony offense, you are now under Texas law and eligible to possess a firearm or ammunition. If you have any questions about that, refer to the document in your plea packet, consult with an attorney. Sir, you're now remanded back to the custody of the Henderson County Sheriff for transport to the appropriate authorities to serve out your sentence. Good luck to you, sir. You can see the bailiff.
Your Honor, Mr. Mormon just wanted me to confirm that it's running CC with other sentences that he's running. The judgment does not have any cumulative.
I didn't see any consecutive sentences.
Yes.
Good luck to you, Mr. Mormon. You see the bailiff. So we have Mr. Moyer.
Yes, sir, Your Honor.
All right. And it's off the record because a lot of cases, what's he pleading on here? On three?
Yes, sir.
We have three separate pleas, plea packets.
Yes, sir, Your Honor.
And
There's
which three is he
sets of
pleading
papers.
on? I just like to know, because which three is he pleading on?
He's pleading on the DOH is the main case. And we abandoned the enhancement in the indictment, but we did seek another enhancement. So it's a second degree with the first degree punishment. It's
Okay.
not the enhancement.
You filed a Brooks notice?
We did.
Okay. And so which, I'm just trying to figure out which cases he's going to plead to. So he's got the 211, which other two?
212 and 213.
Okay. Actually, there's only,
There, I believe there's only 3 indicted cases, Your Honor.
okay. For some reason, I was thinking there's a lot more. I'm sorry. Why y'all were looking at me like I was crazy. All right, then I'll call him. These are cause numbers CR 20-0211, 0212, and 0213-392, all styled State of Texas versus Jerry Moye, and all set for pleas today. It's the state ready.
State's ready in all 3 causes.
And on behalf of Mr. Moye,
We're ready, Your Honor.
sir, is your name Jerry Don Moye Jr.? And are you the same person that was originally indicted by a Henderson County grand jury on this felony case of burglary of a habitation and these 2 felony cases of assault of a public servant?
Yes, sir.
Sorry,
Yes, sir.
I can get you to raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. I do. Lower your hand. Mr. Moyer, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen? Yes, sir. If it turns out you're not a U.S. citizen and you enter into any of these plea bargains with the state, it could have certain negative immigration consequences. Do you understand? Mr. Moyer, have you ever been treated for any mental health or emotional issues? You understand what's going on here today? And Mr. Head, you believe your client is competent?
He is, Your Honor.
Right, then the court's going to find that he is competent. Mr. Moyer, I know that we've already arraigned you on each of these cases. However, would you like the prosecutor to read the indictments against you out loud here in the court? You understand the charges? Well, I'm going to start that burglary of a habitation charge. That offense is a second-degree felony. A second-degree felony carries a punishment range of not less than 2 years, nor more than 20 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. However, it's my understanding that you intend to plead true to an enhancement paragraph that's been alleged, which would, if the court found it true, would make the punishment range that of a first-degree felony. A first-degree felony carries a punishment range of not less than 5 years or more than 99 years or life in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand that range of punishment? And on the assaults, he's just pleading to a straight third?
That's correct.
Okay, and in this, in both of these assault public servant cases, in each of those cases, as indicted without any enhancement paragraphs, those are third-degree felonies. A third-degree felony carries a punishment range of not less than 2 years nor more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand the range of punishment in each of the cases that you are pleading guilty to today? And the plea bargain in each of the cases?
Thank you, Judge. In CR 20-0211-392. 18 years. Plus the train fees and the court costs. This is the one concerned CR 20-02 10 years and CR 20-02. The state will ask this court to take into consideration an unfiled burglary bill and 2 misdemeanors that do have cause and use through permission of the county. 2020-0442-CCL2 and 2020-0443-CCL2. And we're also asking for restitution from Mr. Douglas listing in the amount of $550.
Is that your understanding as to that plea bargain?
Yes, sir.
And is that your understanding, Mr. Head?
It is.
And on the 2 assaults of a public servant?
Judge, we're going to ask this court to abandon the enhancement paragraphs of already reflected. 10 year, and we'll ask for 10 years in each of those to run concurrent with 18.
Is that your understanding of the plea bargain in each of those cases? And Mr. Head?
It is, Your Honor.
Mr. Moyer, a few minutes ago, I asked if you could read and write the English language, and you told me you could. I'm going to go over the same document. There's one in each case. And so I'm just going to show you one, but again, there's one in each case. The agreed plea recommendation is the first document. Did you read and go over in each case the front and back of this document? And did you sign it in each case? Do you have any questions about it? The next document I'm going to refer you to is the court's admonishments and warnings prior to entering a guilty or no contest plea. It's the same document for each case. The only difference would be the cause number at the top. Did you read and go over that document in each case with Mr. Head?
Yes, sir.
And did you sign it in each case? Do you have any questions about it? Do you have any questions about any of the documents in any of these cases that you went over with Mr. Head?
No, sir.
Well, if you read and went over these with Mr. Head, I know that he explained to you that you have many constitutional rights, including the right to trial by jury in each of these cases. Do you understand that?
Yes, sir.
Do you want to waive your right to a jury trial? Do you want to enter into this plea bargain?
Yes, sir.
Then, sir, in cause number CR 20-0211-392 to that burglary of a habitation, are you, as alleged in the indictment, are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
Then where is your, is this your notice?
It should be a Belgian. paragraph 2.
I'm sorry.
It should be a bell jumping prior in paragraph 2.
That's the one he's pleading true to?
Yes,
Oh, I thought you filed a separate notice outside the indictment.
I did. I think in the indictment is a critical.
Where is that notice? That's what I'm trying to find because I got to take his plea to it. I've got state's motion to abandon enhancement paragraph. Here, I'll hand it to you. I can never find anything in these. I'll tell you what, while you're looking, I'll take it after guilt innocence. We'll just bifurcate it that way. And Mr. Moye, you're pleading guilty because you are guilty for no other reason.
Yes, sir.
And in cause number CR 20-0212-392, as to that assault of a public servant, a third-degree felony as alleged in the indictment, are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
And finally, in cause number CR 20-0213-392, as to that third-degree felony offense of assault of a public servant as alleged in the indictment, are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I'll hear the evidence as to guilt innocence in each case.
Thank you, Judge. The state offers 3 exhibits in all 3 cause numbers. State's exhibit number 1 is the offense report. State's 2 is discovery compliance, and state's 3 is a supplement.
No objection, Your Honor.
Admitted in all cases.
Nothing for the rest of the case.
Right. And Mr. Head?
Your Honor, one thing I think we might should just draw the court's attention to it. Each one of the judgments shows 487 days credit. One of the plea sheets showed 438 days, but we corrected that. I just wanted to draw the court's attention
I see
to
it.
that. But with that one clarification, we would rest and close.
All right, then, Mr. Moye, in cause number CR 20-0211-392, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that burglary of a habitation as alleged in the indictment. And do you have that enhancement?
We do, Your Honor. Here was the notice. Can I put it with
Yeah.
service?
And in cause numbers CR 20-0212-392, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that assault of a public servant, a third-degree felony as alleged in the indictment, and the court has abandoned or notes the enhancement paragraph, or no, it's paragraph 1 was abandoned. Okay. And then in cause number CR 20-0213-392, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third-degree felony offense as alleged in the indictment, and notes the paragraph 1 was abandoned. And now, as far as punishment, in CR 20-0211-392, Mr. Moye, he's pleading to number 1 or number 2.
I think 2 is the range of punishment.
Oh, I got you. I thought there was 2.
And 1.
All right. Mr. Moye, now that we're in punishment, I'll have to ask you, sir, is it true or not true that on the 10th day of July, 2014, in this court, in cause number B21-105, you were convicted of a felony offense of bail jumping? Is that true or not true?
True.
And are you pleading true because it is true and for no other reason? Okay. All right, sir. Then in CR 20-0211-392, having found you guilty of the burglary of a habitation and having found the enhancement paragraph 2, the court will follow the plea bargain that sentences you under a first-degree felony punishment range to 18 years in the Texas Department of Criminal Justice. The court will considers in punishing you those 3 cases as alleged in the plea recommendation. You do have 487 days credit and orders you to pay your attorney's fees, court costs, and restitution. In this case, will run concurrent with 0212 and 0213. In 0212, Let me just spell it all out. In CR 20-0212-392, having already found you guilty of assault of a public servant, the court will follow the plea bargain, sentences you to 10 years confinement in the Texas Department of Criminal Justice with credit for 487 days and orders you to pay your court costs. This case will run concurrent with the 0211 and the 0213 case. And in that CR 20-0213-392, having already found you guilty of an assault of a public servant as alleged in the indictment, the court will follow the plea bargain, sentences you to 10 years confinement in the Texas Department of Criminal Justice with 487 days credit and orders you to pay your court costs. In this case will run concurrent with CR 20-0211 and 0212-392. Now, a couple more things, Mr. Moyer, we're almost finished. In each of these cases, I'm showing you the judgment of convictions. Have you had an opportunity to review those in each case? In each of these cases, is your name, the charge, and the time credit correct?
Yes, sir.
All right, sir. And finally, now that you have been convicted of these felony offenses, you are now under Texas law ineligible to possess a firearm or ammunition. Those are actually legal terms. If you have any questions about, you need that back. About anything about that, refer to the document in your plea packet or consult with an attorney. Good luck to you, sir. You're now remanded back to the custody of the sheriff for transport to the appropriate authorities to serve out your sentence. Need to see the bailiff before you go.
Thank you.
Yes, sir. Thank you. Where we get to that?
All right, that's all I had, if I could be
Yes,
excused.
sir. Appreciate you.
Thank you. Mayor.
It's been a long day,
Yes, sir.
but it's nice to get these cases moving.
Yes, sir.
750 and 450. I wish they'd do this math for me. See, I got to do it. 750. I used to be able to do math in my head. Sorry, I'm gonna close that out. It's the most important document I signed. The pay voucher for the attorney. What do we got left? We got one more case, right?
Judge, it's Mr. Greer, and I think that's
Two.
it.
It is.
Mr. Greer, that's it. Oh, Mr. Massey. What are we doing for? How come I didn't? Who's this attorney? We seen John? Are you standing in for him?
I won't mind standing in for him.
Who, John?
Yeah. I saw him earlier.
That was this morning.
Is Mr. Massey here?
What is it set for status? Did y'all have something worked out?
What you like to think of?
Here's what I'm gonna do. I'm just gonna pass it because not like John Scott. He probably didn't know about it. Mr. Massey, when's the last time you talked to him? Oh. Mr. Massey, I'm gonna reset your case to April the 15th at 1:30. It's not like your attorney not to be here. You need to call him and ask him where he's at. He was here this morning. You're free to go. I'll see you in April. April 15th, 1:30. Don't go anywhere yet. You got to get a reset notice. I was going to direct it. All right, sorry. I'm all out of sorts now.
I realized that. I would have texted him earlier. Your Honor, this is Mr. Greer's first status conference. We got a new offer on Monday. We are really close to being able to resolve this, but we would ask for a reset to that April the 15th. Okay.
Ms. Moore provided me with some information this afternoon. I need to confirm. It's not guilt innocence, it's more mitigating towards punishment. So again, that goes to what Ms. Moore was saying in our negotiations. So we're getting close.
What day do y'all want?
I mean, I'm good with a couple of weeks.
April 15th?
We could.
Okay. All right, I'll call it then CR 20-0515-173, the state of Texas versus Rodney Greer. And by agreement of the parties, well, let me ask Mr. Greer, you're the one in jail. You all right with that? All right, well then I'll reset your case to April 15th at 1:30. All right.
That's all I have, I think.
Yes, ma'am. And that'll do it for the 1:30 docket. We are adjourned for the week.